Other things to consider when you're drafting your lease. Know what forms are required. If you're under the Veralta, the VRLTA, there are certain disclosures that are required. If the house was built before a certain time, there's forms that are required. Also be careful with default clauses. I'm looking at an Office Max lease yesterday. We're having to sue the landlord for something. Guess who's bearing the brunt of that expense? My tenant, because there's no attorney's fees clause in there in the event we have to sue the landlord, or in the event the landlord has to sue us, so they're just as much in trouble. But make sure there's an attorney's fees clause in there, and that there's remedy clauses. You know, if the landlord hasn't repaired something, is there a right to cure period? What kind of notices do you need to give them? Things like that. Any questions on that? Who are the parties to the lease? A lot of leases allow for assignment, a lot don't. A lot allow for assignment with not to be unreasonably withheld by a landlord. Once an assignment occurs, the parties to the lease are now the new tenant, whoever the old tenant assigned the lease to, or the landlord assigned the lease to, and the prior party, the other party. So the new tenant, old landlord, new landlord, old tenant. Two parties. With subletting, let's say the tenant sublets, there are now three parties to the lease. Okay? Landlord, old tenant, new tenant.
No, tenant, subtenant.
Well, old tenant, new tenant, tenant, subtenant. Right.
Yeah.
Right. Liquidated damages. People love to put liquidated damages clauses in leases. The courts hate them. They typically won't enforce them. Got to be some measurable showing of damages. Punitive damages are damages that are out there to punish, and the courts aren't going to make liquidated damages punitive damages. Okay? So if a liquidated damages clause appears to just punish the breaching party, the court's not going to enforce it. It's got to be some measure of damages. Guarantees, it's kind of like a cosigner. If you don't think your tenant, if you think there may be a problem with them paying and you want to have a cosigner, make sure that you get the proper guarantees and that they are in writing. If mom or dad says, you know, if she doesn't pay, I'll pay it. Get it in writing, because when you go to court, the mom's going to say, I never said I'd pay it. Options to renew or extend. Make sure that those are included in the lease. Otherwise, you're going to need to do a whole new lease agreement once that lease expires. And lease termination. If the lease just ends, this is an interesting piece of information. A lot of landlords, you put in their lease, I want 60 days notice if you're not going to renew. But there's no renewal provision in the lease, they just want 60 days notice. But if that lease is to end at a certain time, there's no renewal provision, there is a code section that says a lease ends when it ends, no notice is required. Okay? So you can't then go after the tenant for failing to give you 60 days notice. Okay? Be careful with that.